Welcome back. We're updating Chapter 5 on age eligibility. Primary emphasis is age eligibility in the NFL and the Claret case, but we're going to start with Major League Baseball, and we know recently MLB shortened its draft from 40 to 5 rounds. We've sort of been looking at this a little bit before. It could have widespread effects. Ryan, I'm going to call on you as our expert in Major League Baseball. On collegiate, people might stay. Well, they don't get drafted, they're going to have to stay in either JUCO, junior college ball, or collegiate ball. Wooden bat leagues during the summer until they're 3 years out. We have all the age eligibility rules in the book. We won't burden this conversation with, they are page 165 with slight modifications. But what do you think is going on here? And did this have to be collectively bargained, this shortening of the draft, or was that a COVID-related item? I ask without leading the witness too much, Ryan. What do you think?
Yeah, so it's definitely better that it was collectively bargained and insulates it from further litigation because of the non-statutory labor exemption. But there are possibilities that it could have been insulated anyway, building on the NBA trilogy and the court's desire to preserve collective bargaining agreements and collective bargaining relationships and the process, that some courts would potentially find that if this had been negotiated, or if it's only a piece of the collective bargaining relationship and would upend something greater, that the courts wouldn't necessarily invalidate this before that. But it definitely gains a greater shield of legal protection by being collectively bargained, but it's not clear that it would absolutely have to be.
Okay, and again, the rules themselves are 165 and following for each of the 3 leagues in Major League Baseball are summarized at 168, subject to 168 and 169 and following. So on the NBA, again, we summarized the rules. Zach, I always turn to you as our NBA expert. At 167, there have been slight variations since the publication of this book, but we're still dealing with the same basic NBA eligibility rules. So what's happening to get around these rules, which are stated in the book? Not get around, but deal with them.
We're seeing a lot of very creative, but a lot of different approaches emerge in the last couple of years. The first one was Maker. Recently, he was 19, and so he didn't even graduate high school, and he submitted paperwork directly to the NBA asking to be part of the draft. And they agreed. He was allowed to be part of the draft. It was interesting because he actually ended up pulling out and committing to Howard University anyways. So they went through this huge inquisition/questioning process, only for it not to matter too much in the long run. But we've seen this in other ways where some players like famous gone abroad to places like Australia, and they played a year there to satisfy this rule before becoming draft eligible NBA. We've seen more creative ways like Darius Baisley, who signed a $1 million basically internship with New Balance, where he worked in their offices for a year before being draft eligible. And we've seen the G League recently. The NBA has put forward this path to professional pathway where these top high school prospects are paid, I think, anywhere from $500,000 upwards to basically be part of their developmental program. And we saw Jalen Green, who was the #1 overall prospect, and Jonathan Kuminga, who was the #4 overall prospect, both decided to take them up on their offer, and both of them skipped college and went directly to the G League. So I imagine we're going to see more and more of this as this becomes more and more popular, as players find other ways to basically capitalize on themselves and make some money and avoid college before going to the NBA.
Thanks. And what would unionization mean? Is that a good, bad, or indifferent thing? The players would otherwise arguably have antitrust standing because they're individual contracts rather than collectively bargained agreements. Where does that stand now per the PowerPoint bullet points that we've got?
For the G League, as you can see, the G League, they officially formed their own union. So they would be able to now collectively bargain with the NBA and come up with their rules. They would obviously be now under the non-statutory labor exemption, so they can no longer sue under antitrust law. But it depends. It depends on how well they're able to negotiate with the NBA, of course, what terms they come up with, and whether or not that's favorable to them in the long run.
Thank you very much. And Aaron, we're going to finish by just you and I sort of co-teaching what claret stands for in the Second Circuit. Again, we've got a summary of that at 402 and 403, 404, non-statutory labor exemption and the different treatments and what does it mean for Mackey and claret. But in the text itself, you and I have been working on this together for many years now, teaching what is the NBA trilogy, how does that lead to the decision ultimately in the Second Circuit on claret. And now we're reading at pages 156 and following. And again, the NBA trilogy being Caldwell, Wood, and Williams, building to the ultimate quintessential ruling in claret for age eligibility in the Second Circuit. Take us through that on page 158 and following, Aaron, please.
Yeah, so initially, I mean, the district court found that this was a, I guess we'll start with the facts. Claret left Ohio State and challenged the age eligibility rules because he wanted to enter the NFL prior to him being 3 years out of high school. Filed an antitrust lawsuit against the NFL, claiming that that these rules were restraint of trade. The district court actually found for claret, and then as page 158 says, the victory was short-lived in that on appeal, the circuit court then reversed and found for the NFL because the NFL and the NFLPA had collectively bargained these rules using Wood as support and relying on this specific provision, as it says on 158, that although these new members find themselves in disadvantaged positions, it is based on the collective bargaining agreement between the NFL and the NFLPA, and it applies to those who will become part of the NFL because it's the rules that they agreed upon in the CBA negotiations.
And ultimately, claret was a stranger to the union, as was Wood. That's why Wood was a stranger to the union, challenged the restraint on how much a first-year player could be paid, and heavy reliance on that the fiduciary duty only extends to current members. And in fact, the NFLPA took the opposite. It was against claret in his case, because the fiduciary duty extends only to those who are currently in the union, not those who are strangers to the union. So ultimately, his only recourse, well, in the Wood case, the only recourse is to file an unfair labor practice charge against the union, but you really don't have standing to do that until you come into the league and they have a duty to you. So we've come kind of full circle on standing, whether to file a grievance, and we know any grievance is going to go through to final binding arbitration, not to the court system. And really what claret is sort of almost the death knell for is almost anything that's collectively bargained. You don't have antitrust standing. Almost, it'd be very, very difficult at the end of the expiration and a long extension of time, and for the union to decertify and be able to say we're all free agents again, like McNeil, like Brady tried to do with his decertification strategy. These collective agreements, and the league would be very silly to let it go too long post expiration. So as to allow for individual standing for, again, we're talking not so much just rookies trying to enter the league, but anybody who's already in the league to have standing to sue. Just finish with that thought, Aaron.
Yeah. So again, the league is kind of, as we run through a lot of these chapters and these concepts, the league is kind of almost concocted or learned what they need to do to avoid a lot of these lawsuits, where they're leaning, if it's the MLB, on the antitrust exemption from the Kerfoot Act, or, on the non-statutory labor exemption for these other leagues. So the leagues kind of know exactly what they need to do in order to not be sued, or if they're sued, pull this back into, use the non-statutory labor exemption as a defense. So yeah, that the league would never let, a CBA expire, have X period of time, whatever that is, to where the players or the NFLPA would be able to file or decertify and file an antitrust lawsuit, or just file an antitrust lawsuit in general. So the leagues know they know exactly kind of how to go about this. So it's kind of claret kind of tied off that last potential loophole that they had, that the players had. So
terrific. So just Ryan, we'll finish up with you if we could scroll up again. So again, and even though MLB has this antitrust immunity, it still has to comply with the non-statutory labor exemption rules. Just to hit that point one last time, once they're at the table, they still have to comply with good faith bargaining, like we saw in Silverman. They can't just unilaterally impose in bad faith mandatory terms and conditions that were not collectively bargained at all.
Yeah, exactly. Antitrust exemption is a legal technicality about one set of laws, but federal labor laws and other laws will still govern the MOB and their practices. So they don't have a total whole cloth immunity, no matter how powerful the antitrust exemption may seem.
Terrific. Thanks again for your attention on our updates and refreshment of Chapter 5, Age Eligibility. We'll look forward to seeing you in class when you can ask any additional questions that might remain. So thanks for your attention. Have a good evening.